A trial court sentenced a man to death. A higher court looked at the exact same case and set him completely free. No new witness came forward. No new evidence was found. Nothing changed. And yet, years later, that man was sent back to face execution. So here's the question worth sitting with. How does a legal system take away a man's freedom, give it back to him, and then take it away again, without ever finding a single new fact? To understand that, you have to go back to a school bag, a bicycle, and an afternoon in August 2001. It started the way most mornings do. A young girl, not yet 6 years old, got ready for school. Her name doesn't matter for what you are about to learn. What matters is that, like every other day, she left home expecting to come back. She studied at a local school in a small town in Uttar Pradesh. Her parents had no reason to think today was different from any other. By evening, she hadn't returned. The next morning, before 6 a.m., a farmer walked into his sugarcane field to start his day's work and found her body. She had been raped and strangled. The postmortem conducted the same afternoon placed her death within the previous 24 hours. There was no camera, no confession. Nobody who saw it happen. What the police had instead were three strangers. Three people who had crossed paths with the man named Satish that day, each one holding a separate, incomplete piece of the truth. The first person was a man named Anil. Sometime around 2 p.m., Anil saw Satish standing near the same sugarcane field where the body would be found the next morning. Satish looked shaken, out of place. At the time, Anil had no reason to think any of it. Nothing had been reported missing yet. The second and third witnesses came forward separately, with no connection to each other. Sanjeev Kumar Tyagi and a man named Kulbhushan each told police the same specific detail. They had seen Satish riding a bicycle sometime between 1 and 2 p.m. with the missing girl sitting on the handlebar. Neither man had discussed it with the other, neither had reason to lie. On their own, none of these sightings proved anything. A man standing near a field isn't a murderer. A man riding a bicycle with a child isn't automatically a criminal. And there was a problem investigators had to reckon with. Sanjeev and Kulbhushan weren't questioned right away. Their statements came later, well after the body had already been found, after the town already knew something terrible had happened. That gap in time would matter enormously. Later, in ways nobody in the police station that week could have predicted. There was another gap too. When the girl's family first went to the police to report her missing, Satish's name wasn't in that report. Not as a suspect, not as anyone of interest at all. So investigators were left holding two loose threads and a timing problem. A man near a field, a man on a bicycle, a name missing from the very first document filed in the case. None of it on its own pointed anywhere conclusive. But then, investigators found something that changed the shape of the case entirely. During questioning, Satish gave police information that led them to two items: the undergarment the girl had been wearing and his own underwear. Here's why that detail matters. Under Indian evidence law, when a piece of information from a suspect leads police directly to a fact only the guilty person could know, that recovery becomes legally significant. It's not just what was found, it's how it was found and who led them there. Suddenly, three isolated fragments weren't isolated anymore. A man seen near the body, the same man earlier, seen with the girl on his bicycle, and physical evidence recovered because of what he personally told police. The trial court weighed all of it and convicted him of kidnapping, rape, and murder. The judge called it one of the rarest and most brutal cases she had seen and sentenced him to death. You would think that would be the end. It wasn't. Because it was a death sentence, Indian law requires the case to automatically go to the High Court for confirmation, a built-in check against the most irreversible punishment the state can hand down. Satish also filed his own appeal. Both were heard together. And the High Court didn't just review the sentence, it re-examined the entire case. Its conclusion was the opposite of the trial court's. The judges raised three specific doubts. First, the two bicycle witnesses hadn't been formally questioned by police until a long time after the incident. to the High Court that delay was suspicious. If what they had seen was so important, why the wait? Second, when the girl's family filed the very first police report, Satish's name wasn't in it. It was really the man last seen with her. Why didn't anyone name him immediately? Third, Anil's sighting near the field was, at most, suspicious circumstance, not proof of guilt. The High Court ruled that the chain of evidence simply didn't hold together. And under one of the oldest principles in criminal law, that doubt favors the accused. It overturned the conviction. The death sentence was set aside. Satish walked free. For most cases, that's where the story would end. But the state of Uttar Pradesh wasn't finished. They took it to the Supreme Court. This is where the case stops being about one man and starts being about something almost invisible. A moment in the courtroom so small, it's easy to miss entirely. When Satish's own lawyer cross-examined the two bicycle witnesses, there was a chance to dismantle their story completely. All he had to do was ask, "Are you lying? Did you actually see this at all?" He never asked that. Instead, the only question put to them was strangely beside the point. Why hadn't they asked Satish why he was walking the bicycle instead of riding it with the girl on the handlebar? Think about what that means. If the defense truly believed this man were lying, cross-examination is exactly where you would expose it. It never happened. The core claim that Satish and the girl were seen together at that place, in that window of time, was never actually challenged by the side that needed to disprove it. Supreme Court noticed this immediately. And once you see it, the High Court's entire foundation starts to look different. The delay in questioning the witnesses, nobody, not the defense, not the trial judge, had ever asked the investigating officer why there was a delay. You can't hold an explanation against someone when no one ever demanded one. The missing name in the FIR, the investigating officer had actually explained that when recalled to testify later in the trial. The High Court simply hadn't engaged with that explanation at all. One by one, the cracks the High Court had used to justify the acquittal turned out to be the cracks in its own reasoning, not in the case against Satish. Underneath, everything sits one legal idea, and it's the one this whole case exists to teach. It's called the last seen theory. If a victim is last seen alive with a specific person and only a short window separates that sighting from the discovery of the body, courts are allowed to draw a serious interference. Because in that narrow window, the chance that anyone else could have committed the crime becomes almost impossible. But there's a limit built into this idea. If hours stretch into an unaccounted for gap, the possibility that someone else crossed paths with the victim in between becomes real, and the interference gets weaker, not stronger. Here the timeline held together tightly. The bicycle sighting, the post-mortem's estimate of when death occurred, the discovery of the body the following morning. It all sat close enough that, in the Supreme Court's own words, the chance of anyone else being responsible was next to impossible. Picture it as a clock, ticking from the moment Sanjeev and Kulbhushan saw the girl on that bicycle to the moment that post-mortem said her life ended. That window was small. Too small for a stranger to have appeared out of nowhere, taken her from Satish, committed the crime and vanished, all without a single person noticing. That's exactly why the last seen theory carries real weight in Indian courts, but only within limits. Stretch the clock too far, a gap of many hours, a missing day, and the theory collapses because too many other explanations becomes possible. Keep the clock tight, and the law treats the last person seen with the victim very differently. That's the test the High Court had failed to apply correctly. Not because the facts were wrong, but because the reasoning around them was incomplete. There's a second question worth asking you, almost as important as the first. How can a court undo a not guilty verdict at all? In most legal systems, once someone is acquitted, that verdict carries enormous protection. The presumption of innocence doesn't disappear at trial. If anything, it grows stronger after an acquittal. But that protection isn't absolute. Appellate courts can still step back in, only when there are compelling, substantial reasons. If a lower court's reasoning was clearly flawed, or if it set aside relevant evidence without real justification, that becomes grounds to intervene. The Supreme Court's own framing was almost mathematical. A wrongful acquittal of a guilty person is not a smaller injustice than the wrongful conviction of an innocent one. Both are failures of the same system. The job isn't to protect the acquittal, it's to get the answer right. So the court didn't just comment on the case. It reinstated the original conviction and the death sentence, because it found the reasoning behind the acquittal did hold up once properly examined. Legally, this case answers the question set out with. A person can be convicted of murder without a single eyewitness to the act itself. The surrounding circumstances form a chain, so complete that no other explanation survives it. 3 witnesses, a recovered undergarment, a tightly held timeline. Together, they were enough. But there's human side to this that no legal test can resolve. A 5-year-old girl left for school one ordinary morning. She never came back. No verdict. However carefully reasoned, however many times it was appealed, reversed and reinstated, changes that. What this case really leaves behind isn't a lesson about one man's guilt. It's a reminder of how much weight a single word, proof, is asked to carry inside a courtroom, and how the space between suspicion and certainty is exactly where the law is forced to do its hardest, most careful work. 2 different courts looked at the same facts. They reached 2 different answers. Only one of them, in the end, got to have the final word.